family. In times past, whenever there is a dispute, if it is civil, the matter goes first of all before the Olori Epi of the family. And it is up to the Olori Epi to invite some other senior members of the family to sit with him. And that setting provides a system where you can even encourage people to meet themselves halfway. That is to say, if there are two warring factors, Obi, can you hear me?
Yes, I can.
Okay. If there are two warring factions, you can appeal to their sense of justice, to their sense of religion. You can appeal to the sense of history that binds them. It's not a winner-take-all kind of thing. It is not one that meets the case of the claimant 100%. But at least, number one, it does resolve the dispute. It does keep them still friendly. And then it reduces that kind of case going to the law courts. Because, let it be clear, there are well over 50-60% of the cases in our law courts. They shouldn't be there at all in civil cases. There are matters which may have had to be addressed at the, what they call it, Igbemoa Leli, which is composed of high chiefs headed by the Olowo of Owo. In our case, for instance, the Olowo of Owo is a legal practitioner who has also had administrative experience in the civil service. So you have this setting. Then, of course, you have the arbitral setting, where the warring factors may have a recourse to having to sit, maybe with religious leaders. Even at club level, you can have senior members of the club sitting down with warring factors and warring factions and taking a look into the matters before them. So what I'm trying to say is that my concept of justice in Nigeria is that we have unnecessarily shackled ourselves by limiting ourselves to the orthodox means of settlement, of litigation, rather than taking advantage of what the Lord has given to us. And it is one area to look. If you take a look at the Constitution of the Federal Republic of Nigeria 1999 as amended, no role whatsoever is given to traditional rulers. And many of them these days, in Asaba, the Obi there, he's a professor. In many other parts in the north, they are retired generals who really have had lots of years of experience. And then they are also appointed for life. And rather than taking advantage of this enormous existence of personnel and giving our traditions and customs, you have totally alienated them and now conscripted them into this alien system. So we need to take another look.
It's no longer news that our justice system is fraught with many inadequacies, which has become a clog in the wheel of justice dispensation. Many lawyers and human rights watchers have at different times decried the snail speed at which justice is processed in Nigerian courts. One matter that comes to mind is the notorious case of Major Hamza Al-Mustafa versus the state and the murder of Kudirat Abiola, which lingered in court for 13 years, following a series of adjournments and trials within trial. With your experience as one who has been on that adjudication seat for many years, why has quick dispensation of justice become a Herculean task in Nigeria, 62 years post-independence?
In matters like that, clearly there is a lack of integrity on the parts of the dramatis personnel. If you probe deeply and you isolate the dramatis personae as being the prosecutors, as being the defense lawyers, as being the courts themselves, you will find that there has been some evidence of lack of integrity. There is no question at all about it, because there is no issue that is so complex in criminal law which can take a period of 1 year, 2 years, 3 years, 4 years, 5 years, 6 years, 7 years, etc. So I think that the reason for that is quite clear, and we should probe particular cases in this light. Let me deal with other factors.
Okay.
The first one, for instance, is that if the matter is a felony, for instance, it has to get referred to the DPP for advice. So beginning from that stage, you won't be able to follow up to say how long did it take for the DPP to offer the advice to prosecute. Then it goes to the prosecutor that's left the table of the DPP. It goes to the prosecutor. Now, the prosecutor needs as well then to be examined. Do you have all your witnesses? Have you really studied this case properly? Or are you merely glossing over issues? Have you prepared yourself in a way and manner that you are confident that all the requirements of a particular crime have been proved, given the depositions that you have? Because if you have not, many times they go to courts and they ask for unnecessary adjournments under the pretext maybe that a witness is unavailable or some such other absurd reasons. So that is the stage of the prosecutor. The case of the defense lawyers as well, they too from time to time contribute to this, and they may seek adjournments in respect of matters which have some political overture, maybe EFCC matters. Some defense lawyers may be hoping that the matters may be so frequently adjourned as to dovetail into a favorable political regime where indeed maybe an attorney general can just come to court one day and tell the court that he is filing what is called a nolle prosequi, that is to say, a notice of discontinuance of the matter. You will see that in all of this, there's one, a lack of efficiency, that's a total lack of insufficient knowledge of the matter, or a total lack of integrity. These two matters, ability and or competence and integrity, they matter a great deal.
Okay, successive administration installs chief justices of Nigeria. Each of them comes on board with different judicial reforms, practice direction, procedural rules, among others. For instance, the Administration of Criminal Justice Act 2015, which has been widely domesticated by states, was touted to come, to the rescue of removing many of these clogs. Notwithstanding all of this, justice still moves quite slowly. Do these reforms have any impact on speedy adjudication of matters?
Yes, you mentioned the Administration of Justice Act. That was, as you have rightly stated, designed to accelerate trial in criminal matters. And for instance, where before in the middle of a trial, the issue of admissibility of a document may occasion an adjournment in order to appeal an adverse ruling. The Act makes it such that it permits the matter to proceed until conclusion. Then upon conclusion, the party who is dissatisfied may then take the totality of the matter to the appellate court. So if you take it on face value, all these provisions, they should work ceteris paribus. That is to say, provided all things are equal. If they were laws that were located in a totally different environment from our own dear country, Nigeria, they would work because they are working elsewhere. And it brings to mind as well, when I was on the bench, when Tinubu was governor and Professor Yemi Osinbajo was Attorney General, they introduced a lot of massive reforms in civil procedure and criminal as well. I had the good fortune of being a member of the review committee at the time. We introduced some really very revolutionary regulations in civil proceedings, which lawyers refer to as uploading of documents, whereby all the documents you intend to use, you file them with your case at the onset. So you don't come to the trial court asking for adjournment because you cannot really procure particular documentations. Now, it has worked to some extent, but you find that in our dear country, those who practice this law, whether it is criminal or whether it is civil, they have a way of circumventing all of this. And if you go before a judge and a judge says, okay, I must go on with this matter, overruling an application for adjournment, and the lawyer, there has been instances where lawyers have walked out on a court, a most preposterous thing to do, very unprofessional, and rushed to take out some kind of proceedings, maybe application for transfer of the matter. They will say the judge is biased, you know. And I really would like a situation where in cases like that, the issue is treated on merit, and any such lawyer that has been found involved in that kind of ploy ought really to have his name struck off the register. In England, a few years ago, I was on vacation when a matter came before the Court of Appeal, and the lawyer was advancing a matter, he was advancing a case, advancing a principle which had been long settled by all the courts, and their lordships were so incensed that they said, look, this matter is so well settled. Coming up here to now re-argue it, it's really surely an abuse of court process. And they had this case referred to for consideration for by a disciplinary committee. So we really have, you can't stop all the lawyers from engaging in all these ploys, but at least you can ensure that if you do so on merit, yes, there's no problem at all with that, you are within your rights. But if it is found that you do so in bad faith, with the intention only of frustrating the cause of trial and obstructing the cause of administration of justice, there really ought to be a punishment for that. So these matters, the laws are all there. What about those who practice it?
Now, let's take a look at the physical setting of our courtrooms. Many have lamented infrastructural decay, lack of basic facilities in Nigeria courts as one of the banes. It is even said that most courts lack recording facilities, thus compelling judges who resume sitting at 9 in the morning to take notes using longhand, regardless of the number of cases before them on daily basis. How much effect does this have on speedy dispensation of justice in Nigeria?
I can tell you, because in Lagos State we were one of the first courts to have proceedings recorded, having recourse to automatic recording machines, and it's made a lot of difference. And you can sit in there during proceedings and listen to arguments and indeed make your rulings as the case may be, if they are in respect of routine matters, admissibility, whatever, the law is so well settled, you can sit in there, you can make your ruling, and you can ask counsel to continue. When you do it in longer hand, it takes a hell of a lot of time. It wears down the judge. It stresses the judge, and you are not able to function optimally. So there's no question at all about it that automatic recording machines are a most essential tool for efficient performance in the law courts. We have all along been talking about the judiciary. We have not spoken at all about the executive. We haven't spoken about the legislature. We are always in the eye of the storm, and it is not usually remembered that it is because whatever we do is so obviously notified to the public, because proceedings are they admit members of the public, they are public hearings, but we do not have the same means of casting telescopic views on what the legislature does and on what the executive does. And permit my saying it, because the law courts, electorally for instance, because they are not an electoral asset, you know, executives, they pay less attention to them as they would. What I'm saying is that in circumstances like that, I remember El Rufai when he was minister and when he said that money was being demanded by members of the National Assembly so that the bill could go through. They will rush money to set things like that, but when the judiciary asks for money, asks for funding, because we don't go on strike, because we do not really have, as I said, electoral asset, we don't win votes, less attention is given to the judiciary. So I really would want a situation where the executive realizes that the judiciary does occupy a central role in the life of any state and improves the funding of the judiciary in their respective states.
Now, at the elementary level of government, it is taught that independence of the judiciary is sine qua non to a healthy democracy. The Nigerian constitution seems to have enough fire to protect the independence of the judiciary, but in reality, in spite of the statutory safeguards put in place, can we say that the Nigerian judiciary is truly independent?
On paper, yes, it is. And in practice, let me just use the experience of individual judges. When a matter is assigned to you, remember you have taken an oath to dispense justice to all manner of people without affection or ill will, and to be fair to all. Now, in doing that, you are on your own with your conscience and God. No chief judge is going to write your judgment for you, and if anyone attempts to do that, you can call the matter up and it can lead to serious consequences. So in that sense, a judge is independent. You make your own ruling, you give your own judgments, you listen, you take the cases, you listen to the lawyers, you take the evidence, consult the law books, and then you apply the law to the facts and you write your judgment. To that extent, yes, they are independent. But if you just mention the issue of the automatic recording machines, if a court lacks amenities, indeed, if a court does not have the complement of staff that it requires to function. Then the CJ of that particular state may have to go cap in hand to the executive for more funding. So there could be ways of interfering with the independence of the judiciary, and one of it, of course, is to starve it of funds.
Central to the issue of quick dispensation of justice is the conversation on the decentralization of the Supreme Court to remove the burden of focusing on a central system to give final verdicts over all matters, criminal, civil, election matters, among others, from 36 states of the Federation. On the face of it, it appears a factor for delay. Do you agree with proponents of a decentralized Supreme Court? Do you think that's the way we should go?
Let me give you a short story about that. The Supreme Court is the apex court, and there has to be one Supreme Court which sits there to take a look at all appeals from the Court of Appeal. That is the jurisprudential setting that we have. As a student in England, I remember at a law dinner, a woman who approached a young judge and said, "Oh, excuse me, Mr. Raymond, you mean that at your age you are a high court judge and you can give judgment, sentencing the person to life imprisonment, etc., etc.? Oh, that's great. You never do make mistakes, do you?" Oh, and he said he makes mistakes. If he makes a mistake, he will be corrected by the Court of Appeal. If the Court of Appeal makes a mistake, it will be corrected by the House of Lords as they did then, but they now have a Supreme Court. Now, so we have to have one central Supreme Court. I agree that there ought to be many courts of appeal, and that they should sit in many more parts of the country than they are now. But you see, I had occasion in my career to sit on election petition tribunal. I did in Yobe State, I did in Edo State, and I find that indeed, again, about half the cases really ought not to come if people who are charged with these matters did their jobs properly. And the INEC and all its staff, right down to the lowest rung, ought to approach their duties with a greater sense of responsibility and integrity. Elections happen all over the world, in US, in UK. It is not as if you don't have them petitioning against the results, but they are not really as flippantly done or as frequently done as they are here.
I actually asked that question because a country like America, which Nigeria fashioned a presidential system after, has actually decentralized her Supreme Court. Isn't that the way to go for Nigeria too?
By decentralized, you mean that you have a Supreme Court for the nation replicated in all the regions, for instance?
Yes.
No, I think the decentralization that I would subscribe to is a decentralization where you can identify certain matters. You can say, well, matters of contract, matters of tort, that they end up at the Supreme Court of a state. If you take issues of felony, for instance, and particularly where the life of the offender is at stake, it cannot or should not be made to end at the state level. It ought to go to the final Supreme Court. In other words, you know that in the past, many regions, in the West, for instance, we had an apex appellate court where matters in respect of certain subject matters ended there. It's a way, really, of curbing the volume of work that goes to the Central Supreme Court. So, yes, I will support one overall Supreme Court, but some appellate court in the states where specified matters cannot go beyond that stage. It's been argued, for instance, that interlocutory matters ought not to go beyond the Court of Appeal. Why do you need to take a matter interlocutory meaning a ruling that does not determine a matter on its merits, maybe an issue of admissibility, for instance? Why should it have to go to the Supreme Court? This is one of the issues that has been with us for quite a while. So you can take a look at the subject areas and say, okay, well, this subject area, it ends in Lagos State. This subject area can go beyond Lagos State. That kind of decentralization, in quotes, is what I subscribe to.
In the last 30 minutes, I have been speaking with the Honorable Justice Dr. Adeshi Olateru Olagbegi, Emeritus Judge, Lagos State High Court. Honorable Justice Olateru Olagbegi, thank you for sharing your thoughts with me on the big issue.
Thank you too for having me.
Thank you. And let's go on a quick break to take the news update. We will be right back. Stay tuned.
Good evening, thanks for joining us on the news update. Oluwatoyin Omodara is my name. Governor Oluwarotimi Akeredolu has reassured people of Ondo State of their safety after suspected kidnappers attacked construction workers in Owo, killing 2 people. The attack, which took place on Wednesday, claimed the lives of a military officer, a driver, and the kidnapping of one of the expatriates working on the 4.7-kilometer Ife-Somi Mobile Ikare Akoko Junction Dualization Road project. The governor, during a visit to the scene of the incident, described the attack as shocking and unfortunate. The Catholic Diocese of Ondo has announced activities lined up for this year's World Communications Day. According to a statement by the Catholic Diocese of Ondo, the event, which is the 56th of its kind, will begin on Sunday, 29th May with the Holy Mass at the Sacred Heart Cathedral, Akure, by 10 a.m. Thereafter, there will be a reception and lecture on a theme at the Cathedral Hall within the church premises. The statement urged media and communications professionals in the state to attend the event. The theme for this year's World Communications Day is Listening with the Ear of the Heart. This month, environmental sanitation will hold in Ondo State tomorrow. A statement by the General Manager, Ondo State Waste Management Authority, Mrs. Ayo Adeyemo, said the exercise will hold between 7 and 10 in the morning. The statement said there will be no movement restriction during the exercise. Mrs. Adeyemo urged residents to use the period to clean their surroundings. The Federal High Court sitting in Yenagoa has ruled that former President Goodluck Jonathan is eligible to contest the 2023 presidential election. The presiding judge, Justice Issa Amadashane, held that Jonathan's right to vie for the office of president again cannot be stopped by any retroactive law. The coalition of northern groups had bought the All Progressives Congress APC presidential nomination and expression of interest forms for the former Bayelsa State governor, months after speculations emerged that he would join the ruling party. Jonathan served as vice president between 2007 and 2010, but became president in May 2010 following the death of President Musa Yar'Adua. He thereafter contested for the presidential seat in 2011 and won. Meanwhile, a federal high court in Abuja has refused to admit a former Imo State governor, Rochas Okorocha, to bail pending the determination of a suit instituted against the federal government. Justice Eyang Eko declined the request by the former governor to compel the Economic and Financial Crimes Commission, EFCC, to release him on bail. In a brief ruling on the bail application filed by Okorocha, Justice Eko said he was not inclined to admit the applicants to bail. Rather, the judge ordered Okorocha to put the federal government on notice to come and defend his detention. The former governor informed the court that he was vying for the presidential ticket of the ruling All Progressives Congress, APC, and his political ambition would be jeopardized unless he was granted bail. The FCC on January 31 slammed Okorocha, who presently represents Imo West and Sierra District, with a fresh set of corruption charges to the tune of 2.9 billion naira. And that's it on the news update. Join us by 7 for a comprehensive news report. The big issue continues in a jiffy. Please stay with us.
Yes, you're welcome back. Thank you for rejoining us. And if you just joined us, it is the big issue on Osrc TV, and we're beaming our searchlight today on the judicial system in Nigeria. I have with me as our panelist for today, Dr. Gbenga Abimbola. Thank you so much for being here once again, Dr. Gbenga Abimbola.
It is my pleasure to be on the show today.
And we also have Mr. Babatope Okeowo. Thank you so much.
You're welcome.
Great. We all listened to our lead discussant today, Honorable Justice Olatere Olagbegi, retired, and he mentioned a very key part of our society, the traditional rulers, and the fact that we have limited ourselves to only the system of the courts as written by the Western, countries, Western culture. How did we get here? And then the fact that we do not take cognizance of our peculiarities as a people, to decide what works for us.
Yes, that is the point. The point is that we are suffering from what I call cultural imperialism. That is, the Europeans, they came to Africa, they came with their imperialistic posture and mentality to subjugate us and to suppress us. They tinkered not only with our language, but our culture and our way of doing things. And they brought religion, they brought education. We had our own education, but their own education that is called Western education superseded our own. And so their language, French, English, Portuguese, and so on and so forth, now superseded our own indigenous languages. Then their own civilization, they brought it to supersede our own civilization. So, and by the time they were living, they had really greatly, to a large extent, entrenched all these their imported systems on us, to the effect that we had no choice than to run our system according to their own system. Anything to the extent to which our own system differs from their own, our own was considered inferior. But our language, they use a derogatory language to term our language as vernacular. And so we still go with that today. Now, in those days, before they came, our judicial system was very fast and quick, and it was highly effective. In fact, you see at the palaces, at the chiefs, in fact, we had an organized system. There is no cases that go to the Oba in the Yoruba land in those days. Some quarter chiefs, unit heads, they had their own adjudication systems. It is when those cases they could not decide, they cannot appeal and go before it gets to the KBAC's palace. I mean, we were highly organized before they came. But because they now imposed their own, we refused to now bring up our own. But even at independence, we still tried. Those, our founding fathers, they still allowed that's why we had the council of chiefs. But some of our traditional rulers were also members of the legislative council. But when we now, after the military intervention, when we embraced the presidential system of government, we now embrace the Western culture wholesale to the effect that all our traditional institutions, they became null and void in terms of, I mean, their relevance was discontinuous. And so they had no constitutional role now.
Okay, Mr. Okay, well, would you agree that we did not have a choice?
Than to...
Yes.
No, I didn't say we did not have a choice.
You said we had no choice, but
okay,
follow
yes.
through.
Where I'm sorry that I used that at least they had already tinkered with our mentality, our whatever. They had brainwashed us. So that was when we continued. But having stayed long on our own as an independent state for over 60 years, I think we are more than ripe enough to be able to decide for ourselves. But we now have leaders who are not thinking that way. They still want to be oppressing us using this Western system.
On this show, we've often talked about the kind of leaders we have, the kind of followers we have, the fact that we're all one way or the other culpable to, the state of things in Nigeria. He also emphasized the role of integrity in the judicial system, which also cuts across every other sector that you could think about. The fact that as individuals, integrity is not something that people want to even pride in anymore.
When you look at it vis-a-vis this judicial system that we are talking about, if you listen to what Justice Olatoro said critically, he said justice system started from the family heads. A brother or two brothers are fighting, they go to the family head. Now, displeased with whatever decision the Oloriabi must have taken, they proceed to the quarter chiefs before it gets to the palace, which is like the Supreme Court in those days. But now, you see brothers taking brothers to courts directly. That means they have lost that sense of justice that we had in a traditional institution. If I'm fighting with my brother, I will report him to my dad.
Exactly.
This is what your son is doing. He will call the two of us and, okay, settle the matter amicably. Not that I just take him to court on anything. So we, as followers, we have lost our sense of justice. We have lost our sense of decency. So it is now easy for the imperialists to tinker with it. We also see a situation where even the process that drew up a person as monarch is warped from the beginning. The government now appoints monarchs for communities. And once there is any problem, we see the government telling you, you either behave or we remove you. We have seen cases where monarchs were dethroned by king, not by the kingmakers, but by the king, by the government. So it has actually affected our justice system in the traditional way.
It has actually affected, and the fact that brothers, like you said, are not even willing to talk it over first in the families before they begin to go out, because like Honorable Justice Olatoro Lagbaige said, if these cases were handled at that level, then the courts will not be so overwhelmed with the number of cases
they are having.
that they are having.
For instance, if you are having disputes over land, the best place to go is the family heads or the traditional ruler who knows the history of each family, how they migrated into that particular place, who is the original owner of that land. But in a situation where you see a monarch now fighting over land, who will it now go to? we have no choice than to go to the conventional court. And we are bogged down with issue of cases taking many years, especially civil cases. We have a situation even when we know, before the advent of this traditional system of government. I mean, before before the government now tinkered with our declaration, chieftaincy declaration. We had a situation where you know that you are an elderly person. If our father dies, he's the next person to become monarch. So I won't, me, the junior one, I won't need to argue with him. We know that women don't have a right to the stool of the father. But you see a situation where a male child from the female line is now trying to become monarch in some communities. So when you have this, you know that who becomes the king has now become a big problem. So even when you are a king in a community and you are going to court to answer cases about your declaration, why do we not have time to say, okay, we want to settle land matters? So we know that we have a lot of views on this thing.
So the issue of integrity that he talked about is also in the traditional system.
Yes, because the way they emerge.
Yes,
the way they emerge.
But who is to blame? It is the government. The government, two things. I blame the government for two things. One, government deliberately interfered with the emergence of monarchs. So when government has put his hands and legs into it, interfering in the selection process, you cannot throw up people of integrity. That is one. Then number two, because our system, the government we are running, does not give any constitutional power or role to traditional rulers, so they don't have respect.
Like he talked about the constitution.
Yes. So once you don't give them any constitutional role, then who is going to go? You go to that place. You are wasting your time because their decisions are not binding. And let me tell you, before the advent of the colonial masters, even why did we have quick dispensation of justice those days? The evidence system, the issue of gathering evidence was very fast. So you bring in your witnesses, and if the witnesses, if the leaders that are to judge, if the witnesses are not sufficient to get the evidence, they go try the traditional way. They consult the oracles to decide that who is telling a lie and who is saying the truth. You understand? So that was why it is quite. But today, you could see that the evidence, I'm not a lawyer, you quote and quote and quote, you adjourn and adjourn, and you use, everybody will know that this is the truth. But facts and truth are different, in the conventional courts. But in those days, they go with the truth and not only with the facts.
To buttress what he said, there was a theater I watched when I was going up in this station. It was, a man gave money, he traveled abroad, not the abroad that we are talking about. Maybe went to Lagos to work, and he was sending money to his younger brother to build house for him. When the man now came back, the man said, I was building my own house. So it resulted into litigation. They went to the palace. The younger brother said, I built this house, it's my own. The elderly person that was sending the money said, I was sending money to him. So that, okay, you have to carry something on your head. So they took that thing on their head, not knowing that there was somebody that was writing whatever he was saying when he was carrying that thing. And they allowed their wife. So the first wife was saying, please, you know that you wanted to rob this person. Please don't fall down, no. Because once you fall down with this with this covering, then the evidence will show that we are not the owner. The other person too was saying, you know how we suffered to send this money to build this place. So please don't fall down so that we could reclaim our property. So when they now dropped the coffin before the monarch, they now opened the coffin and discovered that there was somebody that was taking records of. So you now presented so they now gave the property to the original owner. So these are some of the ways that, apart from using oracles, that we get quick dispensation of justice. Not a situation where you file a suit today, the next 10 years you are still going to court on adjournments.
And like you said, let's hope that we'll ever get to a point where our constitution will recognize the roles that they play.
I don't know why it's taking. I don't know why it's taking. We have done several amendments after the 1999 constitution, yet they have not included traditional institution in the amendment the amendment. I don't know why. What is stopping them? Like Justice Olabegu said, for instance, in Owo today, the Olowo is a lawyer. He had risen to permanent secretary status, so he must have known how to do both administrative and he knows it. So why can't they give such institution a constitutional role so that whatever he pronounces becomes the law? But no, I don't know why the people who are in charge of our law has not done that. Has not amended it in such a way that will give traditional institution the constitutional role.
Just to buttress that of traditional institutions, you will see that those who are being crowned as monarchs today, they are no longer minnows. Some of them, they are successful businessmen. Some of them, they are successful academics, professors, PhD holders. Some of them, they are successful
Generals.
Retired generals. Some of them, they are successful experts, either in the finance sector, in the legal profession, in medical profession. They have seen it all. So they have the experience and they have the education and the exposure. So if they give that is just one of the aspects. Apart from traditional institutions, there is what we call alternative dispute resolution system. The alternative dispute resolution system will be that at least the landlords association, for example, are just in a community. There's a dispute between one landlord and the other. Instead of them to go to the regular court, the landlords association will have their own committee on dispute resolution. People can approach them, and some of these alternative dispute resolution, justice there is even better served. How do I mean? They are not going to, in fact, they are not going to be overall winner and overall loser. They will decide the case to the extent that both parties will smile at the end of the day. But in the regular court now, if you go to the court, one person will smile, one person
All right, let's move on from that now. He mentioned the administration of the Criminal Justice Act enacted in 2015, which is supposed to actually make dispensation of justice faster, quicker, and then ensure that, justice is not denied. However, it seems like we have so many beautiful policies, so many beautiful laws enacted, so many beautiful reforms that are not working. Is it a function of our system, our people, what is it?
It's a multiple, it's a complex thing. One, we have weak institutions in Nigeria. We have strong personalities but weak institutions. It is the institutions that regulate whatever happens in the society. Now, when we have weak institutions, how do you want any law, any rule you make to function? Because it is the institutions that will make these things work. Now, in the legal profession in Nigeria, it is only the special courts that are forced to dispense with justice at the right time. For example, the electoral disputes, tribunal. Yes. If you go to the regular court, you will suffer. But if you go to the tribunal, they give them, if not because of that, some lawyers will also want to extend and extend. So when I said weak institutions, we don't have strong institutions to correct this. Now, number two, the lawyers, they because of one thing or the other, because, people just want to circumvent the system, because the system, the lacuna is there. They will begin to seek for necessary adjournment, and if the trial judge is trying to say that I don't want to allow, they might accuse him of bias. But if there is for example, in electoral matter, once the tribunal officers know that it is time bound, they will tell the lawyer, we have to finish this case between this and this time. That is one. That is number two. Number three, because our system has allowed the almost all criminal cases end up in the Supreme Court, and we have only one Supreme Court in Nigeria, in Abuja. and you want...
So do you subscribe to that?
So,
decentralized
yes.
Supreme Court.
In fact, we say we are running a federal system. No, I'm saying it that it's a fake federal system. America that has 50 states has 51 constitutions and 51 Supreme Courts. The federal Supreme Court, and each state has its own Supreme Court. If we cannot try 36 Supreme Courts, why don't we have 6 Supreme Courts? I mean, there's 7, 1 in Abuja, then 1 in each geopolitical zone. So, you know why
are we different with?
Let me land before you tell me.
Give me one minute. We have, before now, in the entire South, we had Ilorin, Court of Appeal. We had that of Benin and Ibadan in the Southern, maybe one in Enugu. So, but now, we have one in those states. We have many appeal courts now. Do you know what the funny aspect of it? They have been giving contradictory judgments. Are you getting it now? This appeal court will give these judgments on the same matter. Another appeal court will go to another, give a contrary on the same subject matter.
So you think the judiciary is actually responsible for part of what we're going
No, what I'm trying to say, trying to get is not that we should polarize it by education. No, what we need is effective judicial system, not having too many appeal and Supreme Court. No, it won't solve the matter because I always have to select which Supreme Court to go. Not that there's nothing we have in Nigeria that you cannot abuse.
Anyway,
are you getting my point?
Yes, please. My point on that is this. Now, even the appeal courts we are talking about, guys, you cannot take a case outside of Ondo State now. You want to appeal, and you leave the appeal court in Akure. You go to appeal court in Ibadan. They do, but it's because we have not regulated it. That is why you are talking of effective system. What is the system? The system should be that this Supreme Court is to take care of all cases in this region. That means you cannot appeal to another Supreme Court outside of your own region. That is one way. But even this one Supreme Court we are having in Nigeria, the judges, they are overburdened. They are overworked. Because even all other special courts that are not regular courts, their cases still end up on the table of these Supreme Court justices. Electoral matters, they still take it to the Supreme Court. So
not all electoral matters. Before the issue of contrary judgments, decisions, governorship used to end at appeal court. But now, because of the contrary judgments, they have to move it to Supreme Court. So let me just say one thing about that. I've won awards covering courts, and I know what I'm talking about. There was a man, after 6 years in court, he was discharged and acquitted for criminal offense. So after that, he went, once he's supposed to be happy and start going, he just sat down. They asked him, go now. He said, where am I going? Where can I go?
After 6 years.
After 6 years, nowhere to go. He said, you go back to the prison. He said, in the court, in court 2. I was there. He had no place to go. 6 years in court, going to court, in prison. So we have a lot of cases that have dragged for so long.
Why did they drag?
So, because one, we have to look at it. Once we have a person allegedly commits murder, instead of taking it straight to high court, they will say the magistrate court. We will now go to DPP. We want to get legal advice, which can take 1 year, and the person will be in prison. After that, we start having several adjournments. And you see, there was a time I went to this correctional center at Lokuta. The judge was so overwhelmed with plethora of cases. He said the cases he had in is over 100, and we have to write judgments. So what I'm saying is that, one, we have to have more judges. Are you getting it now? But not to have more jurisdiction. We have Supreme Court in Ibadan. We have one in the 6th Jubilee. We will still have the same problem we have when they now move cases. There will be a time that we will not have to have one Supreme Court. We are appeals arising from those Supreme Court, we still have to go because there will be Nigerian system. We abuse it. There will be so many contradictory judgments, and we have to now have to say, okay, let us have one Supreme Court that appeals from those Supreme Courts. We now have the Supreme Court. We now go. So we have to look at our system, our psychology, our integrity before we are talking about having deep presidential system of government.
Yes, we have a common ground. The common ground is that the judicial officers are not enough. Not only at the Supreme Court, even at the
Lower court, exactly.
They are
That's
not
my point.
Fine. Now, if we have Supreme Court divisions in different geopolitical zones, that does not mean that if a case is decided at the Supreme Court in the Southwest zone, that is still subject to appeal to another Supreme Court. No, because Supreme Court is Supreme Court. Appeal Court is Appeal Court. They can have different divisions, but one is not. They have concurrent jurisdiction. If you say we have a Supreme Court in Ibadan, for example, it is not subservient to Supreme Court in Abuja. It is the same Supreme Court. But whatever the case, we are talking about shortage of judicial officers. And why do we have shortage of judicial officers? Because we have too many disputes. And why do we have too many disputes? Because we don't have a working system. Our system is very weak. Let me give you an example. Many cases shouldn't have come up at all if our system is running. I have a colleague, is your colleague, is my colleague, a journalist who retired. You know, government has said he can no longer pay pension and gratuity. They don't do contribution.
Contributory pensions, yes.
Now, in the contributory pension scheme, that person retired now, and immediately he retired. It's over a year now. Immediately he retired. He filed up his papers, submitted. His PFA, the pension administrator, has yet to clear him to pay him even a pension, not for 1 month, not to talk of gratuity. You think that person continue to suffer for over 1 year? No, nothing comes to him on monthly basis. How does he pick his bills? Then he has to go to National Industrial Court. So now, if the system is working, does he have to institute any case in the first instance? These are the things. And if our electoral system, if our elections are free and fair, and people know that once you win squarely,
the people decide.
And the people decide, then who will go to court to begin to bother the tribunals? There are some countries in this world where they are closing down their prisons because they don't have customers. But in Nigeria, our own correct.
I want to have addition to what you said about having more judicial officers. We need to have more facilities.
Yes.
So as to accommodate these judges. Go to our courts. In Akure now, we have industrial courts, we have federal high courts, we have state high courts that have coordinate jurisdiction. Are you getting it? And all appeals from that place goes to appeal court that we have in Akure. So, but when you go to these courts, discover that there are magistrate courts. You see that somebody will sit in the morning in the same magistrate court, and that one will sit in the afternoon. That means we need more courtrooms to accommodate these cases that we are having. And there are many cases, like if we are allowed our system to run, there are many cases that should have gone that far. For instance, if I beat up Dr. Nibola, he needs to report me to our elderly brother, not going to. So there are many cases that
shouldn't even go to the
civil cases, I mean, minor cases that are criminalized.
Let's talk about infrastructural decay, which the Honorable Justice also alluded to. The fact that maintenance culture, we know, it seems to cut across in Nigeria as a problem. And the fact that, you know, justices are expected to take their notes in longhand in the 21st century, that really brings, you know, worry to the mind that rather than listening to the arguments, the person is trying and struggling to take notes, in, you know, using longhand. Should we still be at that level?
They adopted a system, front loading. They still allow you to take notes. So you, especially in civil cases, you have to front load your arguments, your briefs. You serve the other person, he also serve you, and you now come to the court and adopt it. That's what they do. So it makes cases faster. But at that, we still need more facilities. We still need the courtrooms to be internet compliant. I don't know of any of the courts in Ondo State, both federal, state, appeal court, that have internet facility. It doesn't exist. These judges use their own personal data, so which is wrong. We are even sending something to them via mail. They have to use their own money to buy data.
Because the environment is not even
conducive. So we need that. And we still have one problem that I have to see. The same, let's say, state high court now, the salary is paid by different person, by the federal government. The facilities are to be maintained by states. You can see the conflicts. Once you are appointed as a judge, your payroll goes to the National Judicial Council. But the facilities you work with will be maintained by the state government. And how much does the state government now have to maintain many facilities, many roads, schools, hospitals? And we are not still talking about judiciary. So there are many problems that are affecting the state government, are preventing the state government from actually taking care of judiciary.
So do you think
I think
a truly independent judiciary is the way to go?
The way to go is the deployment of technology. Even our profession, journalism, if we look back, you would know that in those days, when you first became a reporter,
yes, I was using
you use midget. So the best was to use midget, but you still go with your writing pad. You write, and when you use midget to tape record, you will now come back and begin to play back and be stopping it, pausing.
Yes.
Nobody does that any longer. So with your smartphone and with some smart gadgets, you can do what we call voice to note. That even as you are playing back, is recording on your personal computer, and you just edit. The judges don't need to be using longhand any longer. So they have to, if they have technology, as cases are being argued, they are being recorded, then they can play back or can make a transcribe of that system, read it, and they now form their own notes. You know, they also have recorders. But whether the recorders have given the judge or the judge wrote it himself, as long as the judge signs it, it becomes his own property. So, but some people are now saying that we want him to write personally.
That is wrong.
That's wrong. We have recorders in the court, and the judge also has access to recorded information, either the audio or the video or the.
But that's what he's saying, that some of these courts do not even have those facilities.
That's what I'm talking about now. That
are you getting that the court
are not automated?
Should be ICT compliant.
You know, you said something, Babatokokewo, that the way it is right now, the federal government sets up the courts and then they ask the states to actually
appoint judges.
And taking care of the facilities.
Yes.
It is because we are not running a true federal system.
If they were truly independent, the judiciary, because it's not like they don't know that, of course, having what it takes in terms of technology, the facilities that could aid quick dispensation of justice. And
remember Buhari signed an executive order the other time that has ceded autonomy and financial independence to the judiciary. Just like Babatokokewo has said, Nigeria system, I have said it, we have weak institutions. The governors who are to implement, how many of them are really implementing? The only autonomy judiciary has in Nigeria is that their salaries are being paid from the consolidated fund, and that their appointment are subject to the ratification of the National Judicial Council. But their nomination still comes, from the state.
From the states.
Some governors can file and say that it didn't pass through my table. Why are you submitting it to the National Judicial Council? So what we are saying is that the autonomy is in paper. If there should be autonomy, that means the budget, the finances should not be controlled by the Ministry of Justice. And the Ministry of Justice is not judiciary, it's executive. So now, although it doesn't mean that judges should now be the contractors to procure and do one thing or the other. But when we have strong institutions, it will regulate some of these things. Sometimes the chief judge, who is supposed to also be assigning people to cases and taking cases, he or she will be bothered with administrative duties that will overwhelm him or her. And some courtrooms are leaking. that even when cases are going on, rain will be falling.
No, it's not funny.
It's not funny.
I was actually listening to a retired Justice Olushola Williams, and she was saying that it's so burdensome for these judges sometimes when they have to combine their roles as well as the administrative running. It's too much of work for them.
It's too much of it. Work.
More like.
Of course. It's just, she said the truth. We have, like we have said, I want to use Ondo State Judiciary as an example. The CJ will assign cases to judges. Yes, it also sits in his own court as a judge. So, administrative judiciary, it combines the two. And it's just an individual. So, and that's why you see them growing old.
And he also sees to the smooth running of all the courts under the.
Although he doesn't supervise the judges because they are colleagues, but at least he's still the head. And so, whatever happens in the courts, where they
even the welfare of judicial staff is this sees to it.
So he has too many roles to play as an individual, and that's why you see them growing old quickly.
Right, if you say that, then it cuts across because every sector in Nigeria seems to be going through.
But you have to look at theirs. Thank God none of us is a lawyer. But you have to see that those who go to court will know that there are a lot of jobs for judicial officers.
Okay.
We have criminal. We have divorce cases. We have not to be there.
We have statistics has it that about 70% of inmates in Nigeria's correctional centers are not even supposed to be there. Many are there awaiting trial, much more than that.
Yes.
And that actually most times affects the common man on the street. Because when it comes to high-profile cases, some have alleged that it's given very quick, attention, and then they quickly resolve it so that the person can move on because of who is involved.
Well, that's what I saying. I said we have weak institutions. When we have strong institutions, everybody is equal before the law. But when institutions are weak, then people circumvent the law, and that is what we talk about. Who you know. Where the rule of law prevails, you don't need to know anybody. All you need to do the right thing, go scot-free. Do the wrong thing, get hooked and bogged down. No matter who you are. So until we come back to that, and that is why I have said it that I don't know the kind of government we are running in Nigeria. This presidential system is like we are not mature for it. It's too expensive. Because it has made the elected officials and appointed officials to be too much powerful. They have access both to power and to wealth. So at the expense of the masses that they say they are leading. So maybe we can begin to look at how we can come back and tinker with our structure of government to accommodate our own peculiarity. Because the way we are going now is I'm not seeing anything better in the nearest future. We are going to be having more cases. Now, what is
the primaries
that are going on now, a lot of cases are already piling up that are going to flood the courts, both the tribunal and also, pre-election matters
at the detriment of other cases in the courts.
Because some of these cases, all these cases, the cases that will come up now, they are pre-election matters. They don't go to the tribunal, they go to the regular courts. And so, some people who are already awaiting trials, their own case will be pending. The judges will have to attend to all these things first.
And there's one thing I want to mention, and I will appeal to our governors. I don't know when somebody was convicted. Maybe he used to die either by hanging or by firing squad. And the case has dragged from trial, appeal, and Supreme Court.
And concluded.
And has been concluded. And we are still keeping that person, feeding him with government money. And we are complaining of congestion of courts. I don't know why governors, since 1999, no governor has signed.
I think it was only
Oshomole. He wanted to sign.
He wanted to sign.
There was too much pressure on him. So that is.
Thank you that you are bringing this up. It is a sheer irresponsibility as far as I'm concerned. With due respect for our governors, because once you are elected, you have both privileges, rights, and as well as responsibilities. As you have the right to execute powers in civil matters, you also have the right to execute powers in criminal matters, because you are representing God. Once somebody has been convicted to die and all options of appeal have been exhausted, it is your responsibility. You have a duty. A duty calls on you to sign the death warrant. Look, and once you refuse to sign, that means you are afraid of exercising your powers. And yet, the most dangerous part of it is that these criminals, they now go and break the jail and free those people. That's why we're having all this here.
Please, let me just add this to it. Governors don't sign. That's too bad. We have said that. But there's another one. You know, somebody was convicted of a particular crime. Let us say the one that happened recently. EFCC convicted, through trial convicted two former governors. And during their trial, you know that many cases we have to wait. So after 7 years of being tried, they were convicted. The president woke up one day and gave them parole. So what happened to others that have similar cases? What will happen? Will it not darken the morale of the judges that whatever I do, they will see me freed? So why am I myself? So the governors, the government must do something critical about this. Not just allow all of them to go.
And then it will serve as a deterrent
to
others, because if people begin to see that nothing is happening afterwards, it will continue.
Let me give you another. The rules of the rules of the courts, the rules of cases, deciding cases. We also need to look at it critically, because we say we have a shortage of judicial officers. Yet somebody will take up a case, even for years, and hear it, and at the advanced stage, when the case is being concluded, the person is promoted to a higher court, and the person delivers the judgment, and you now go to appeal court or Supreme Court, they will now say that he was not qualified to deliver the judgment. Is he not still a judicial officer? Somebody who has not even retired, who is still serving, and he was the one who had the case ab initio from the beginning to that point.
All right.
And we have
Justice Solate, I want to say this. Mention something that you were handling the case. It got to a point of judgment. The person filed a case, arrested the judgment, asked you that you should disqualify yourself from that case, that he has no confidence in you, and the case now
transferred.
Starts over from another court. Is it not a problem? So we have to look at that.
We have to look at. So one of the major impacts of slow dispensation of justice in Nigeria has made many people to resort to, giving and getting justice themselves. The issue of jungle justice, mob actions here and there, self-help is what we are seeing today. What does this portend for the integrity of Nigeria judiciary?
Well, it still boils down on what we are talking about. It's just that we Nigerians, because we have a weak system, we have a system that gives room for shortcut. That is why people want to circumvent. Otherwise, it shouldn't have arisen in the first instance. Now, if everybody is equal before the law, then people will behave. But because all animals are equal, but some are more equal than the other, that's why some people believe that this person may be highly connected. If we allow him to go to face the court, then connection may free him of this crime. But that is not a justification for jungle justice. It's never a justification for self-help, but it's also an indictment on our judicial process and also our. You apply it to a high-ranking government official, then everybody will have confidence.
Where there's no justification for mob action.
There is none.
None whatsoever.
Yes, I want to say this. A situation where somebody is caught committing a crime is taken to court, the court gives that person bail and goes out again to commit more crime. It's also a problem. So our law enforcement agents, our judiciary must look into that so that somebody that is facing, say, burglary and stealing does not leave the court to commit robbery or murder. So we have to look at our criminal system so that we don't allow criminals to walk free, so that people do not take laws into their hands.
And also, to add to it, the government, it will begin to ask questions from government officials, both elected and appointed. Let me give you an example. Any case, criminal cases, they are offenses against the state, primarily. Most of these big-time cases, especially murder or whatever, they are offenses against the state, even though the victim suffer directly, but it is the state that prosecutes. And there is a provision in our laws, in our books, that if the Attorney General of a state or the federation wakes up, once judgment had not been delivered, even if the case had been concluded, if he says the government is no longer interested in this case, that's the end of the case. I think such things had happened, and people will now say, ha. I think such people, the head of that government, either governor or president, and the said Attorney General, if at the end of the day all these things are revisited, if they have found that they have wrongfully discontinued with a case because of special interest, that that's why I said our institutions are weak. So that when you are Attorney General or you are a governor, you cannot just say Attorney General, go and tell the court that we are no longer interested.
So people must be made
because
to pay for
what you want to do must be the interest, the interest of the people.
Yes.
If you do it against their interest, then you must be
ready to pay.
Totally run out of time. Many thanks to you, gentlemen. Dr. Gbenga Abiola, thank you so much. Mr. Babato Okewo, thank you so much.
Thank you very much.
Till we bring another burning issue your way, same time next week. I am Obi Chukwemeka Oti saying bye-bye.